Hello everyone. This is a criminal procedure topic, the dual sovereign exception to the double jeopardy bar, and it's linked to Chapter 4, Part A1 of the Miller and Wright text. It's often true in the law that if you understand the exceptions, you'll probably learn a little something new about the reason for the rule itself. That's also true here. Here we go. So what are we worried about with double jeopardy bars? What is it that the double jeopardy clause is trying to prevent? Well, this Fifth Amendment provision, no person shall be subject to, for the same offense, to be twice put in jeopardy of life or limb. This provision, it is often said by the Supreme Court, prevents a second prosecution after an acquittal or a second prosecution after conviction, or even multiple punishments for the same offense within the same proceeding. But the key idea here, as we'll see along the way, is that it's got to be for the same offense. Did any of these classic evils of double jeopardy situations happen to Vito Lanza and his co-defendants in the Lanza case from 1922? Pretty clearly, yeah. The experience of Lanza was one of a second prosecution after a conviction. Now, this was a Prohibition-era case from the Seattle era. By the way, this guy here is Matt Starwich, who was the sheriff in King County, which is Seattle, and he's shown here destroying confiscated liquor during Prohibition. At any rate, in this case, Lanza and the co-defendants were convicted under state law first, so prosecuted in Washington state courts for manufacturing, transporting, possessing liquor. They were convicted, they were fined $750, and then the feds came along after that and charged them. And they said, wait a minute here, double jeopardy, you're trying us again. This is a second prosecution for, after a conviction. It's the second prosecution. And they said it's based on the same offense. Even though the wording of the federal statute might be different, maybe slightly different, proof required for the crimes in state court and in federal court, their theory was that this federal prosecution was a prosecution for the, quote, same offense, because both the state statute and the federal statute derived from the same constitutional authority, that is, the recently enacted 18th Amendment that gave Congress and the states, quote, concurrent power to enforce prohibition. So that was their theory. It didn't work. So the court's reasoning here was to grant that maybe this could be the same offense, but ultimately the key fact here is the fact that it's two different governments bringing the charges. The people of the state of Washington, acting through their agents, the prosecutors and the state courts, have enforced their laws, but then the people of the United States, a different polity, a different source of authority, are bringing action under their laws. And so these are two different sovereigns, the sovereign people of Washington and the sovereign people of the United States. And these governments derive their power from different sources, from different groups of citizens. And so in classic political science theoretical terms, these are different sovereigns. And each polity, each group of sovereign citizens can protect its own peace and dignity and enforce its own criminal laws without worrying about the effect of the trial on this defendant the first time around. By the way, it's fitting that the Supreme Court decided this dual sovereignty question in a prohibition case, because up until Prohibition, the federal criminal law enforcement footprint was tiny. There were very few federal criminal code provisions The federal government brought very few cases. They very often did not, they typically did not overlap with the coverage of state codes. There was some overlap, but in practical terms, the number of cases where both the state and the federal government were likely to file criminal charges were relatively few. But then along comes Prohibition, and you've got both government at the state level and at the federal level enforcing essentially the same laws. For the first time, you have a big practical area of overlap. So that's why we see this issue popping up in the 1920s. Now, the next major application of this dual sovereignty exception that shows up in the Supreme Court case law is Bartkus versus Illinois. We've got here Bartkus, who is initially acquitted in federal court for robbing a federally insured S&L. The FBI says, drat, we really should have gotten that guy. We got his co-defendants. We got convictions against them. So the federal court suspends the sentencing of the co-defendants. The FBI continues to collect evidence. They turned that over to state authorities, and so Illinois files robbery charges against Bartkus and is convicted, and Bartkus challenges the validity of this conviction in Illinois state court and says, as a matter of double jeopardy as applied to the states through the due process clause, this conviction should be overturned. The Supreme Court, by way of Justice Frankfurter, pictured here, disagrees and says that the dual sovereign exception controls here and will continue to stick by that, so that the people of Illinois are allowed to prosecute Bartkus even though the people of the United States have already taken their shot. It's true he experienced two different trials, but this is just a consequence of having a federal system with two different sovereign peoples involved. Bartkus had an interesting argument for treating dual sovereignty differently in 1959 than the court did in 1922. Bartkus says, you know, we've been noticing in other cases that you're starting to create, you, the Supreme Court, are starting to create more of an integrated national law enforcement organization. And so you've been disfavoring what we call silver platter doctrines, that is, those situations where state agents can collect information breaking the law and then turn it over to federal agents, or vice versa. And so in other areas, especially the search and seizure area, the court has said we're going to disfavor silver platter doctrines, and we're going to force all the agents of all different governments to follow the rules set out in the U.S. In the federal Constitution. Bartkus claimed that same reasoning should apply here, and that you should recognize the reality of cooperation between different levels of government, and hold one set of agents to the standards established for other sets of agents. But ultimately, the Supreme Court disagrees in this context, unlike what they did in the search and seizure and a few other contexts. Finally, Bartkus also had an interesting argument for an exception to the dual sovereignty exception, an exception to the exception, claiming that maybe you can recognize that dual sovereigns can go forward with trials, but maybe not where the agents of the two different levels of government cooperate too closely. And in this case, the feds were working hand in hand with the state investigators, and really the state courts were only acting as the agents of the federal government in their quest to get a conviction against this guy after they failed the first time around. Sort of an agency theory, and this is the basis primarily for the dissenting opinion. Ultimately, though, the majority opinion by Justice Frankfurter rejects this theory, suggesting, first of all, that there's lots of precedent for more of a blanket dual sovereignty exception, and the court points out that if you do allow this kind of bar against different governments going forward. You might create some real coordination problems, particularly where the penalty might be small for one government and large for the other. For instance, small for the feds, large for the states, and then maybe the feds go first and they wipe out the possibility of the state getting its much larger penalty later on. In other words, governments may not be equally vested in the criminal prosecution. The court also notes that state statutes now are addressing this, and so this doesn't have to be exclusively a federal matter, a federal constitutional matter. As we'll see in a minute, that has continued to be true. Now, this turns out to be one of those settings where institutions other than courts have really taken the lead. And in a very interesting development, immediately after the Bartkus opinion, within weeks, the Department of Justice issued a policy that later became known as the Petite Policy. It was issued by this Attorney General, William P. Rogers, appointed by President Eisenhower. The policy, as originally announced, was meant to protect defendants from the burdens of multiple prosecution. So the prosecutors themselves were recognizing, hey, we recognize that it is a problem for defendants to pay the attorney and to go through the rigors of trial over and over again. So we want to make responsible use of the power that we have under the dual sovereignty exception. The policy was also supposed to promote efficient use of federal resources, Department of Justice resources. It's a waste of effort to prosecute everybody twice. And the policy was meant to smooth out federal-state relationships. Even though it's possible for both the states and the feds to bring cases, sometimes they'll be stepping on each other's toes, and so the prosecutors thought it'll be a good idea for us to declare a policy for when we will go forward alongside the states. This policy gives guidance to federal prosecutors when they're in a situation involving a possible prosecution in federal courts based on substantially the same acts or transactions that were involved in some earlier case, whether it be a prior state prosecution or some earlier federal prosecution. In that setting, when should the federal prosecutor go forward? And the policy lists several substantive criteria that are described here. I won't read through them. And it also gives a special process that you have to go through if you're going to bring a re-prosecution. The key idea here is the substantial federal interest, of course, but an interesting part of the policy is that the policy says that federal interests will be presumed to be vindicated even by a prior acquittal. So the fact that some government, whether it be the state or the feds themselves earlier, brought the case and there was an acquittal, they did not, win a conviction as they were hoping, that fact alone can't be enough to justify going forward with the second federal criminal trial. So instead, the policy says you've got to show something extra, more than that. Not just an acquittal or a low sentence, that's not enough. You've got to show maybe there was incompetent or corruption or intimidation of the witnesses or the earlier prosecutors. Or if you can show something concrete showing jury nullification, or maybe unavailability of evidence, not just evidence not used to its full potential, or evidence that should have been brought in but it wasn't, but evidence that truly was not available the first time around. Or perhaps the state case failed because it was based on a crime element that's not present in the federal code. Or finally, if the federal charges in the first case, if this is a federal re-prosecution, and if those first federal charges were excluded out of concern for co-defendant fairness. In those kinds of situations, you may be able to go forward. Those are the kinds of things that are the extra that you have to show above some earlier acquittal or low sentence. In addition to the substantive criteria to justify a federal re-prosecution, you got to jump through some extra hoops if you're going to bring a re-prosecution as a federal prosecutor. So you've got to submit the matter for signature by, the big boss. You've got to go up the chain to the Assistant Attorney General to get permission to do this. And if you fail to do that, it may be that DOJ will come behind you and dismiss your case later on unless the AAG makes that decision retroactively. So you've got to jump through some extra procedural hoops here. Now, does this policy in fact stop prosecutions from going forward? Sometimes yes. It's awfully hard to know how often because you'd have to reconstruct the thinking of federal prosecutors everywhere as they're deciding not to do something. Awfully hard to track down how many dogs did not bark. But we can come up with anecdotal evidence of some cases anyway that are not brought. There are also examples of cases that look to be pretty close to the line anyway on the petite policy, and they are carried forward anyway. So there's room for debate about just what kind of impact this policy has, but certainly it appears that at least in some cases prosecutors are refusing to go forward because they say it's a new case would be inconsistent with the petite policy. Carrying forward with this theme of other institutions that step in to take the lead where courts have not been very active, state legislatures are key players here. So you read a New Jersey statute that says if you've got a prior federal prosecution on any topic, it is a bar to a New Jersey prosecution based on, quote, the same conduct, unless that New Jersey statute that might apply there has different elements and addresses a, quote, substantially different evil, or perhaps if the New Jersey statute was intended to address a substantially more serious evil, or if the federal case hasn't been completed yet when New Jersey began. So interesting example covering lots of different crimes from New Jersey. We've also got an example here from Ohio involving prior federal drug prosecutions, a prior conviction or acquittal under the federal narcotics laws. If you've got that, then Ohio, you can't go forward with your drug prosecution here. Why limit it to drugs? Well, narcotics prosecutions would be one of the major areas of overlap where you don't really have substantially different perspectives in the state or the federal systems. They're not addressing substantially different evils, to use the words of the New Jersey statutes. So state legislatures sometimes will step in and say, for purposes of conserving state resources and out of concern for the possible oppressive experience of defendants who face trial after trial for essentially the same wrong, we will limit our officers to one shot, and we'll defer to other governments if they're willing to go forward with the prosecution. Let me close with a suggestion. Try applying the petite policy to the facts of the attack on Rodney King by officers of the Los Angeles Police Department. By the way, this here is pictured here is Stacy Kuhn, one of the officers involved in the attack. It's the facts are described in your book. They're also available lots of other places online and so forth. Based on those facts, as you may know, the federal prosecutors went forward with a second prosecution after an acquittal of the officers based on state charges. How do you go about reaching that outcome under the petite policy? If the petite policy doesn't block this re-prosecution, would it reliably block any prosecution at all. You might also ask, how would this prosecution decision come out if you had started off with a federal prosecution and then there was a second prosecution in New Jersey? Let's say that the incident happened in New Jersey. So an interesting application opportunity for you here to watch these rules, these dual sovereignty rules play out. So on we go.